Good afternoon. Welcome to another SERMAPod. My name is Brian Rosenblatt. I am General Counsel for SERMA. And with me today is Puya Partow-Navid, a partner at Safehearth's office in Los Angeles, California, who specializes in intellectual property, trademark, and patent law. Puya, welcome. Thank you for joining us today.
Thanks for having me. My pleasure to be here.
Our pleasure. So today we're going to talk a little bit about some trademarks. We were hoping that this would have been tied into a larger celebration of Pat Riley getting to monetize from the Chiefs' victory over the Philadelphia Eagles in the Super Bowl. Unfortunately, that did not happen. As we all know by now, the Eagles beat the Chiefs handily. But we start talking about Pat Riley, and why? That's because the Chiefs were going for a quote-unquote three-peat. Interesting term, great phrase, and actually is a trademark. So why don't we just jump right in with, Puya, tell us, what is a trademark?
A trademark is a protection for your brand. It can be the protection of your word, the protection of your logo, protection of a sound like the Netflix The Dome, a protection of a color like the Tiffany's blue box. It can be a protection, trade dress is a protection. Like if you're in California or a southern state, you walk into an In-N-Out, you know you're an In-N-Out. You don't have to look at the sign. You walk into a Starbucks, you know you're in Starbucks. The way, the look and feel of the Starbucks without
McDonald's, red and yellow, the golden arches. McDowell's, the golden arch.
Yeah. So it is to protect your brand and to protect against customer confusion. I call it the grandma test. Like if I tell my grandma to go to the store and buy Coca-Cola or some let's say some random product like a video game, and if there's two video games that have the same logo or same name, they might be confused. And that the whole goal of trademarks is to prevent that customer confusion, because there's brand loyalty. You know, some goods and services. If you want Tiffany's jewelry and you see that Tiffany's blue box, you know you have the Tiffany's jewelry. You're not getting a knockoff.
Okay, so I think we can understand protection of a brand name. This is your company. This is your entity. You are protecting it from untoward competition in the marketplace. You don't want consumers to be confused.
Correct.
How do we get to the Lakers winning 3 NBA championships in a row and their coach getting to use a relatively common phrase, three-peat? How do we get protection for that as a concept?
Good question. So it wasn't common until the Lakers won actually 3 in a row. So before that, when they were on the verge of, they had won 2, 87 and 88, and there was I believe it was Byron Scott who mentioned Three-Peat, and Pat Riley sat on that a little bit, had a shower thought, and said Three-Peat. So the word Three-Peat came out. And what happens is each trademark is tied to goods and services. So he filed, well, actually, so backing up a bit, and I tried to do my research on this, and I couldn't figure out the answer. So there was a company called PDP Paparone, the Paparoni, which interestingly enough is the Italian name for Scrooge McDuck in the Disney cartoons. So
Okay.
in my research for this, so they had filed the application in '88 for a three-peat. Pat Riley, they assigned the trademark to Pat Riley. So based on my research, some websites say that was Pat Riley's company originally, and then he just changed the name to Riley & Co. Others say it was owned by this man named Bijan Kherzi, who had a three-peat company, and I haven't been able to verify like the background on this. So long story short, they assigned the trademark to him. but this was only for clothing. So his protection originally was any clothing that says Three-Peat, he protects. So that his brand would be clothing or accessories that have Three-Peat on it. So you could use Three-Peat to maybe have a Three-Peat restaurant. You could have Three-Peat water bottles. His original protection was just clothing. And then from there, and so they didn't win. They didn't win. They got defeated by the Pistons in '89. And unfortunately,
Sorry, I'm from Detroit originally.
So
love Isaiah and the boys.
that was a good series. So it didn't become, it wasn't a common term, and he was able to eventually when they won it. But he started making T-shirts, and the thing with trademarks is you actually have to use it. You can't just squat on a trademark. So you have to show that this is in use in commerce with the goods or services that you've applied for. So every time he makes the T-shirts or he's selling T-shirts with Three-Peat on it, the trademark is in use. So that's how he was able to get it, by trademarking Three-Peat for those specific goods. Since then, he's expanded it to any souvenir that you could slap Three-Peat on.
Class 16 for the bumper stickers, the decals, the paper, the pennants. Class 21 for the collector plates, the mugs, and the tankards. I'm looking at the USPTO site right now, and it is just rife with Riles and Company's filings.
Yes, exactly. So a class is associated with a good and service. There's classes for restaurants, classes for like software, classes for accessories, classes for clothing. Anything you can think of is tied to trademark class, and that's how you get it. Your question about if it's a common term, that is actually an issue. If your trademark becomes a common term, then you lose your right to the trademark. This has happened with Frisbee, elevator. I
think Kleenex was one of the famous ones.
Yeah, that was. Google is trying to prevent this from happening. They want you to say, I ran an internet search instead of I ran a Google search, because eventually if you say, if an internet search if Google search becomes common term for internet search, then they theoretically might lose their trademark.
Okay, so we're talking about keeping it from being a generic term versus a distinctive.
Exactly.
Okay. At what point does a common phrase, Three-Peat, become distinctive or gain that secondary meaning?
Well, it is if it becomes the common term, generic term for. Let me backtrack. Because it's only for T-shirts, a Three-Peat isn't the common term for T-shirts. So it's Kleenex is a generic term for a tissue. So that's when it becomes associated with the goods and services. A generic term for those goods and services. So if we ended up calling T-shirts Three-Peat from now on, if Three-Peat became a generic term for T-shirts, then he would lose his trademark for that.
Okay, so there's a distinction between the use of the word Three-Peat on a T-shirt, on a tankard, on a decal, versus that actually being the product in and of itself. There is no product called Three-Peat.
Exactly.
That remains a concept.
Correct. So he doesn't have the trademark on the concept of Three-Peat. He has a trademark on putting Three-Peat on your T-shirt or bumper stickers.
So is it open season for us to go ahead and file trademark protection in any unclaimed class using Three-Peat?
Well, this is...
As long as we use that term in commerce?
That's a good question, because it comes down to now, if it has become... Because he has so many trademarks on it, then there's a likelihood of confusion that if your Three-Peat is going to be confused with his Three-Peat. Theoretically, you can. The trademark office might bring up issues with this. You can, if there comes a point where a brand is so well known that you can't go and use it for another class. For example, let's say Coca-Cola isn't known with a body shop to fix your car. But you can't go and open up a body shop called the Coca-Cola Body Shop, because Coca-Cola is such a well-known brand that their trademark office is going to say, there's going to be customer confusion. They might think that your body shop is associated with Coca-Cola, the drink. But if you have a less known brand, for example, let's say, I don't know.
What would stop opening up McDonald's hardware?
Well, that's the issue. You don't want people, because McDonald's is such a well-known brand. The trademark office might argue that there's going to be customer confusion. But if it was a lesser-known brand, the Hamburger Shack that you have a trademark for, and then you open up a Hamburger Shack hardware store, if for some reason that you thought of doing that, there's not going to be an issue there because they're so distinct. So there's a fine line. There's a line at some point the brand becomes so big that you can't start using it for anything else. And I don't know if Three-Peat has become to that. You might be able to sell Three-Peat software, and it's not going to be any issues because they're not going to say this is confused with the T-shirts because Three-Peat isn't that well known of a brand.
Okay, interesting. So patents are intended to protect inventions,
yes,
newer novel processes. Copyrights protect newer novel artistic expression once fixed in a tangible medium. Trademark is meant to protect the branding or the source of origin, right?
Yes.
When we think about, and in my world on the entertainment side of things, I have clients that are sophisticated but confuse the concept of copyright and trademark all the time. Copyright, it has to be new or novel. That means somebody hasn't used it before, hasn't come up with it before. Is there a novelty component, not as in novelty merchandise, but is a newness component required for trademark and trademark application? Or is that really just it hasn't been or is not being used in commerce at the time of application?
There's no newness requirement, but there's a requirement that it's not descriptive. For example, if you have a barbershop and you want to call it the haircut store, that's going to be a descriptive mark. You can't trademark what you're actually providing. I had a client once that wanted to run a website where you can figure out the cost of bottle service in Vegas before you go to the club, and he wanted to call it the bottle service website. And I said, you can't trademark what you're actually providing. So there's that requirement. There's some ways around that. You can get onto the secondary supplemental register, but for the rule of thumb is don't have a generic term for what you're actually descriptive of what you're actually doing. Also, common terms like if you are trademarking an ice cream shop and calling it Rich's Gelato and ice cream store, because gelato and ice cream are common, you can't trademark the common terms. This is why you'll see misspellings in phrases for they didn't accidentally misspell the phrase. I can't, maybe links, LINX, you'll see that a lot.
So does that explain why Planet Fitness spells Judgment Free Zone JUDGEMENT?
Probably, yes.
Okay. So Three-Peat, has this term just become so ubiquitous that we now presume that it is common? It's just that's how persuasive or how pervasive it has become, the use of it?
I mean, it has become common, but it hasn't become common with the goods and services. That's like the fine line. And that, this Three-Peat issue, I was inspired to write my blog article about it because I saw ESPN Instagram post about it, and then I did some more research and researching the PDP Paparone. There was a whole Reddit thread about it on the NFL subreddit, and people had that question. It was like, well, Three-Peat is so common, how can Pat Riley trademark it? So, and the distinction is, it is common, but it's common for Three-Peats. It's not common for T-shirts. It's not common for bumper stickers. That's the fine line we have to draw.
Okay. So let's put this mark into actual use then. The Chiefs, sadly, didn't win the Super Bowl. And hypothetically, I don't know what Pat Riley did or didn't do, but would Pat Riley have been able to profit from the use of the term three-peat in the lead up, in the promotion to the Super Bowl, and had the Chiefs won following that? And if so, how?
Yes, he would have, because once you have the trademark for it, let's just use his T-shirt or apparel class, for example. He has the right to, if anybody is using three-peat on the goods and services that he has the trademark for, he can prevent them from using it. So if the Chiefs wanted to make clothing with the word three-peat on it, they would have to license the use of that term from Pat Riley. Otherwise, they would have to stop or selling T-shirts. So, it happens a lot. You find out someone's infringing your trademark, you send them either a cease and desist letter, or you say, you know what, here's your opportunity to license from me, and you get a cut. And apparently he's made a good amount of money off of this. He's made it when the Bulls won their three-peat. He made approximately $300,000 off of that. When the Lakers got their three-peat. So anytime someone wins a three-peat, he's hoping for that three-peat to come in. So that's why he was rooting for the Chiefs, most likely.
So does he have to continuously use the three-peat mark in commerce, or can he? I mean, three-peats happen so rarely that last time I don't remember the last time we had one in basketball. It may have been the Lakers.
Yeah, it was the Lakers. That was the last one.
Okay, so but that's been what, 20 years plus?
Correct. So
how has that term been used or monetized since then? And in order to allow him to continue the protection.
Yeah, when you file your trademark application, you can either file an actual use application or an intent to use application. So at some point, you need to show that I'm actually using this in commerce, and you have to send a specimen to the trademark office, which is usually a picture. Like let's say if it's apparel, you'll send a picture of your T-shirts or the website selling your T-shirts. Every 10 years, you have to renew your mark, and you have to show that it's still in use. So you have to send a recent sample of that your mark is in use. So as long as three-peat T-shirts are being sold somewhere, then the mark can be renewed. So I don't know. That's actually a good question, and I should have researched this. If the Lakers are the last team that win a three-peat, and that was 20 years ago. I don't know where he's still selling three-peat T-shirts, but I'm assuming they're still being sold somewhere. So as long as they're still being sold somewhere, then he can renew his trademark.
Okay. You mentioned he may have earned or made $300,000 when the Bulls won. Is that just pure licensing fees?
From my understanding, yes.
Okay. So when we talk about the use of music, sometimes we get into mechanical royalties, compulsory royalties. We get into some actual set rates and whatnot. When we're dealing with a trademark, how are we setting those licensing rates and the royalty rates? How are we doing that? Is there a statutory construct for that, or is that just a free market system, whatever you can negotiate?
Free market system, whatever you can get. So
okay.
If you don't want to license it, you don't have to. There's no compulsory license. There's no. It's arm's length deal.
Interesting. How do we go about policing the use? Because I can imagine my son's fraternity down in Kansas would have had three-peat T-shirts that they would have been wearing and having some fun selling on campus, but I don't think they would have ever purchased a license. How do we go about protecting or enforcing?
That's a good question. There's actually services that you can register for that will monitor use. So they will monitor websites, they will monitor Amazon, they'll monitor, um, you know, the channels directed to your goods and services. So let's say if you've trademarked for software, it'll monitor software that's coming out to see if it's being used. It'll also monitor. So every trademark, before it's actually registered, it's published, and it's published for 1 month, and you have the opportunity to oppose it. So they'll monitor the whatever is being published as well to make sure that no one is trying to trademark something similar, and you'll have a chance to oppose this as well. So that's one way of policing it, is seeing who else is trying to trademark it. The other way of policing it is services that will monitor the channels of commerce for you. And you have so you can sign up for the service, and you can also do your own research. Your attorney can do it for you, but it's usually more cost effective to sign up for one of these trademark monitoring services. And there comes a point where if you don't police your trademark and you let everybody start using it, then at some point they'll argue that you haven't been enforcing it and you lose your rights to it. So you do have to enforce your mark. So if your son's college made it, but that's a small use. It's not going to become a nationwide use of it, and there's no way really to police it. That's why some stuff fly under the radar. But
I can envision individual fraternities and individual groups all over campuses, all over the country, doing that kind of thing, as opposed to one collective.
Yeah, it means some uses are hard to police, but if it becomes all of a sudden the fraternity starts selling it on the internet and it becomes like viral, then that's when you step in and say, hey guys, FYI, we have the trademark for this. We have to stop you, because if we let you do it and we let the other people do it, then we lose our own mark.
Okay, so that actually raises a really interesting question for me with the rise of social media, the rise over the past many years. It's here now, right?
Yeah.
Phrases, trends go viral almost overnight. I guess that's the definition of viral. How does that virality, how does that ubiquitous nature, it's just everywhere, how does that impact the enforcement of the trademarks? Does that just come back to monitoring companies are just hand over fist monitoring nonstop?
To some extent, yeah, but it's also Three-Peat could be viral, but if it's not viral in the use of your goods and services, then at some point there's a line of if your protection is limited to a specific class, then you can only police that specific class. But if it's tied, if you have your goods and services maybe tied to social media or entertainment services, then you can go after the people using it for like entertainment on social media.
All right, so law school hypotheticals, right?
Mm-hmm.
Riley has the Three-Peat trademark for use on T-shirts. Okay. Let's say we want to go ahead and do a podcast, entertainment goods and services, class 41, a Three-Peat podcast, for example, which is not yet protected.
Correct.
It sounds like we could do that. Is that fair?
Yes, most likely.
What if we then wanted to sell T-shirts celebrating or showing off the branding of our podcast? Is that getting into a infringement situation?
Yes, because then you're selling the goods that he has the protection for. So,
but I'm not selling a Three-Peat. I'm selling my logo on a shirt.
But it's still Three-Peat. So it still says Three-Peat. So he has the exclusive right to Three-Peat on the T-shirts. It doesn't matter. Go ahead. It doesn't matter if your podcast is named Three-Peat and it's not tied to actual winning 3 championships in a row. It's still the phrase Three-Peat is on the T-shirt. So it might not be tied to the original intent of the mark. You could sell Apple software that's for monitoring your Apple farm, but it's still going to say Apple software on it, Apple on it, and it's going to be confused with Apple's trademarks. If that makes sense.
Okay. So, do we get into a utility factor then with the use of the mark? And I think of this in the context of, in past years where we've registered a band's name under Class 41 for entertainment services. We'll do it for sort of T-shirts. We'll do it for recorded music. But in the T-shirt category, what was that, Class 25, I think, you're always asked to submit a specimen, submit an exhibit showing its use. Is there a distinction between the use of a logo on a shirt versus the actual branding and name of the shirt entity?
I'm not following the question.
Hanes Beefy T printed on the front of the shirt versus Hanes Beefy T as the logo and the style of the shirt. Is there a utility component there that we need to be concerned about, or is just no? You're using Three-Peat on a shirt, that's protected. You can't do it.
You're using Three-Peat on a shirt. You can't do it.
So even though my podcast is called the Three-Peat Podcast, I can't put that on T-shirts.
No, it's because it's going to be confusing. If it's to the point where it's confusing, if someone's going to say, "Oh, I see a Three-Peat on your shirt. Is this tied to the Three-Peat company, or not?" If it's going to cause customer confusion as to the source of the goods, then that's infringement. I mean, there might be something. There might be something there of if it's just the logo there and it says the Three-Peat Podcast, and then you say, okay, now I know that this isn't related to the goods and services. Then there's an argument there to be made. I see what you're saying now. If it's not on the back, and then you say, okay, now I know. If it's on the front and it says the Three-Peat Podcast, then you do have an argument that it's not the confusion to the source of the goods. But if it's on the back label, then you might say, okay, now this might be the actual brand of the Three-Peat T-shirt.
Okay. Well, that raises another question then, I suppose. Could another team, the Chiefs, for example, in this past November, it looks like they're the number one team. It looks like they're going to make it to the Super Bowl. They're thinking about, we're going to win that Three-Peat, first time ever in the NFL. Could the Chiefs, could other teams, could other companies use a similar trademark? And I don't know what it would be, a tri-peat or a three-team peat or whatever variation, without having to license or without getting in trouble with Pat Riley.
That's a good question. It depends on how close it is. So, if you in Coming to America, they had McDowell's. If you open McDowell's, is it close enough to McDonald's to cause customer confusion? If you have Tri-Peat, is it close enough to Three-Peat to cause customer confusion? I'm sure Three-Peat would try to make that argument, and then you go to court and you battle it out. Or Tri-Peat, applies the Chiefs apply for the Tri-Peat trademark. It gets allowed. It gets published. Pat Riley's company is monitoring the publications and the register, and they see that the Tri-Peat mark has been published, so they file an opposition saying, guys, wait a minute. We think this is too close for comfort. We're going to go to the TTAB and oppose your trademark.
Okay. And of course, if it's a close enough battle, I suppose that newer entity could work out some kind of a licensing to, hey, don't oppose it, and we'll kick you back a little bit lesser license fee or something to that effect.
Yeah. I mean that, or if the company is, very aggressive, they can say no. We don't want you to do this at all. There's instances of that. An interesting one is actually OpenAI has applied for the trademark for ChatGPT. It hasn't been allowed, but they're going after entities that are using GPT in their name and they've opposed every trademark that's been published that has GPT in there. They have a ton of oppositions against that, and sending cease and desist letters to websites that are using GPT in their name.
They just don't want anyone else using that moniker. Just stay off of GPT.
Exactly. They have trademarks for GPT-3 and GPT-4, but ChatGPT and GPT by itself have not been registered yet, because the argument is that they're generic terms for GPTs. And
did they become so prevalent, so overly used, so commonplace too soon before they were able to get their applications in?
No, it's because I can't remember off the top of my head what GPT actually stands for, but it's the generic term for a large language model. So that's why it hasn't been allowed yet. So, but they are trying to sandbag it and prevent others from getting it. And you have a small company that's a startup, maybe trying to use XYZ GPT, and then you have to deal with an opposition from OpenAI, and now you have to pay attorney's fees. So you either pay the attorney's fees and battle this out at the TTAB, or you say, you know what, I give up and I'm not going to pursue XYZ trademark.
Okay, so legal strategery, we're just increasing the cost of getting into the marketplace and doing business by throwing the legal fees on top.
Exactly.
Okay. So interesting that you mentioned GPT-3, GPT-4. I was talking about Three-Peat. How close is too close? And I guess maybe it goes back to the likelihood of confusion, but I'm looking at the USPTO's website, and Three, Pete, I see is protected. What I haven't seen yet is the number 3, Pete. And maybe I just haven't done that search yet, but is that too close?
I think that and I think he might have that from what I read when I reviewed it, that he has Three-Peat, he has different spellings of Three-Peat, and I believe that he has a number. Yeah. So
there it is. I see it.
Yeah.
I see it. There it is for jewelry, at least.
Yeah. 3-Peat, Three-Peat.
Although here it is for jewelry. Here's a different company that owns it for fertilizer.
Yeah.
And here's another one for fitness classes.
So that goes back to, Three-Peat isn't that strong of a brand where they can prevent others from using it for fertilizer. But for example, if you wanted to make Coca-Cola fertilizer or Apple fertilizer or Google fertilizer, there's a stronger case that there's going to be customer confusion. I mean, granted, Google isn't going to be in the fertilizer business, but they have a stronger case because their brand is so well known to prevent others from going into that space.
Everybody presumes that it would have to be them.
Yes.
There's actually an application. It's dead. There's an application for Three-Peaters, close, which was filed by Big Three Basketball, which I think is Ice Cube's three-man team league. Interesting. Okay. So Riley's got Three-Peat. Terrell Owens, I know, has he's got a brand. Other athletes are coming out. Tom Brady's got TB12. With other athletes, personas, building powerful personal brands. How do you see the rise of individual branding impacting the future of trademarks in sports, at least?
I don't think it's going to change anything. It's just going to, people are going to be more conscious of their brands, and with the NIL situation going on, it's going to become your name. You're going to start trademarking your name sooner or your brand sooner to protect it, because that individuals are like TB12. I actually had someone message me earlier this week, and they said their son is a high school baseball player, and should they trademark his name right now? And I said, well, are you selling T-shirts with his name? Are you like what goods and services are there? But they said, yeah, we have T-shirts with his name on it. Should we trademark his name already? And I'm like, so that it's with NIL coming in. I think you're going to see much more of this, and much more people protecting their their brand, their logo. It's going to expand.
Is that a matter of? I guess that's just a matter of people recognizing larger and deeper revenue and additional revenue streams that are available, and therefore going out of their way to protect them sooner rather than later.
Correct. And I think social media has that, because now you have a platform to, once you become, a TikTok star or Instagram star, and you have your own brand, you're tying your name to those entertainment services. And then from that channel, you can sell your T-shirts, you can sell your goods, you can sell your merchandise, and you have to protect your brand from those channels. And you have it's easier to start a T-shirt company or sell T-shirts with your logo on it now. So, you have to protect it. You have to get ahead of the game and think about all the avenues.
Let me ask you this, because you had mentioned the I don't know, if a middle school player or a high school player who's playing baseball, should we sell those T-shirts now? What level or what form of sales are required? Is it enough to make mom and dad, grandparents, cousins, siblings buy those shirts? Does that constitute commerce, or does it have to be something a little bit more extensive than that?
Well, it has to be interstate commerce. So you can't just be selling the T-shirts at the high school game in Los Angeles and consider that international. You can't set up a table at the game and sell them there and consider that being used in commerce. That's a state registration. But if you have a website where anybody from any state can go and use it, then you have interstate commerce, and that's a national, because trademarks are federal, so it has to be used throughout the United States. So it has to be used. Selling it through a website is commerce. I don't know. You don't have to show that it's actually been sold. You have to show that
it's offered for.
Yeah, offered for. So
interesting. So intellectual property, I love it. I think it's cool. I got a certificate degree from law school in it. It's the world that I live in, obviously the world you live in. It sets up a situation where it creates a limited time monopoly. We want to protect those properties. Copyrights have a certain length to them. Patents have a certain length to them. Trademarks, I think, are just as long as it's in continued use. With more athletes, and really with sports and entertainment really kind of blending, it's all a form of entertainment. But with more athletes trademarking elements of their personal brands, how do we strike a balance, or should we strike a balance between protecting individuality and preventing monopolies over common expressions?
Well, I think trademark law protects that from, you can't, if it's a common term or generic term, like common phrases, you have to disclaim. So if you're TO to touchdown king, you can't trademark touchdown by itself. So you can say rich touchdown king. That might be your trademark as well, because it's the entire phrase. So common terms cannot be trademarked in and of itself. Then you have to disclaim them from your application, so that you don't have exclusive the monopoly on the word touchdown in and of itself. So
okay,
that, I think the law itself protects from that from happening. I mean, obviously, sometimes some things get by, and then that's what the courts are used for. But for in and of itself,
I couldn't protect a trademark for example, chocolate candles by claiming chocolate or claiming candles, but perhaps the conjunction of the two may be distinctive enough to go ahead and do that. Is that?
Yeah, that's what I was getting at. Yeah.
Okay. Interesting. Interesting. Okay. Well, I think we're just about out of time. What other thoughts or what other advice would you give our listeners about brand protection, or well, possibly even not infringing others' protected brands?
Good. Think about this while you're developing your brand. Get in touch with your trademark attorney as the brand process is going on. Some people also trademark too early. Like they'll trademark their logo and then they ship the product, or like 6 months into it, they decide that they want to change their logo because now you only have you've trademarked your specific logo. So make sure your logo is set before you go through the process.
That's okay. So real quick, I want you to touch on this one just a little bit more. This is advice that I give to my recording artists all the time. Protect the name, the actual word mark. Don't worry about the logo because you're fickle. The logo is going to change 6 months from now, 2 weeks from now. When you start dating somebody else, they're going to change the logo for you, whatever it is.
Yeah.
And of course, the other part of that is, I love what you said, and maybe it's very self-serving for the lawyers, but knowing when to file those applications, knowing when to seek protection. How do you advise clients that the cost of bringing your IP attorney on board is a cost of doing business that should be factored into your day one budget?
Yeah, because you are going to either get yourself into trouble by not having the IP attorney there, and then you end up doing all this work and you end up saying, oh my gosh, we're infringing this trademark. We have to go and start everything from scratch, where you could have paid $300 and ran a simple search to make sure that you're not infringing anybody's mark, as opposed to going and doing thousands of dollars and then you have your oh no moment and you have to start everything from scratch. The opposite of that is, you get your IP attorney involved and you say, and he says or she says, look, what you're going for cannot be trademarked because it's generic. You want to start a website to have bottle service prices and you want to call it the bottle service website. That's not protectable. Go think of something else, or we can work with you to think of something that you can protect. There's and it's not that
brand development as well.
Yeah. There's a lot of times when we deal with clients that have generic terms or descriptive terms and they're already deep into the process. And then we say, guys, sorry, like this isn't protectable, or this is infringing, or maybe you should try this. And a lot of times people think that they need the trademark right away. And, you're like, well, let's just make sure the business is going before, you trademark it. There are situations where you want to trademark it. You're a big manufacturer and you know that you're going to sell this internationally and you've done your due diligence. And so you file it right away or you file your intent to use. But in other cases, it might not be necessary. And it's not, the cost of your IP attorney isn't that much to do like 30 minutes of work to get to tell you you're on the right path or not. So get your IP attorney involved sooner.
Perfect advice. Thank you. All right. This has been another SERMAPod, and I'd like to thank Puya, our guest, who's been here with us today, again from Safe Hearth in Los Angeles. Puya, I hope that you will be joining SERMA shortly, and indeed we will have we've got Seminar 3, that may be a trademark application shortly, in Los Angeles the first week of April. So hopefully we'll get to see you when we're in town for that. And this, again, is Brian Rosenblatt signing off on behalf of SERMA and SERMAPod. Thank you.
Thank you very much. Thanks for having me.